Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gav. I'm a senior member of the IEEE and a partner at the Edwards Wildman Palmer law firm in Boston. The IEEE is presenting this podcast in conjunction with a column that I co-author that appears each month in the IEEE's Computer magazine. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, we discussed the patenting of software. In this podcast, we will discuss some issues regarding the Foreign Corrupt Practices Act, or FCPA, that we covered in our February 2013 column in Computer magazine. Joining me today for this podcast is my colleague Steve Huggard. Steve is a partner in the Boston office of Edward Wildman Palmer. Welcome, Steve.
Thanks, Brian.
Steve, the FCPA seems to be a minefield for companies that do business outside of the United States. Certain company practices that used to be tolerated or perhaps even encouraged are now subject to scrutiny and could lead to criminal prosecution. In your practice working with companies having international dealings, what are the kinds of things that you're seeing that could run afoul of the FCPA?
Well, Brian, anytime a company is dealing internationally in areas that are both competitive and involve the government, there is a risk, especially in certain countries. And the government, your listeners should understand, looks at certain countries as being higher risk than other countries. But if you're dealing with customs, for example, getting items through the customs area, there may be a competitive urge to not pay all the duties, and you may find someone who's willing to overlook some custom duties in exchange for something in their pocket. That's obviously illegal and can get you in a lot of trouble. Building permits. You may want to get a building permit quicker. You may want to get a building permit for an area which you might not otherwise be authorized to get one. That's an area where there's high risk. Anytime you're acquiring a company overseas or engaging in a joint venture, entering into a joint venture with a company that is not in the United States, you have to be extremely careful to make sure that that company has not been engaging in conduct which would violate the Foreign Corrupt Practices Act. Because if it is, you can become infected, as it were, by its bad conduct and be liable both civilly and criminally, depending upon the facts, for that company's bad conduct.
So assuming a company does something that's in violation of the FCPA, how does that escalate? In other words, how do the authorities become aware of what occurred, and what do they usually do next? How do they approach the company?
There used to be a rule of thumb in my book anyway, that the government became aware of criminal conduct or bad conduct through what I called the two X's, ex-spouses and ex-employees. But now there's a whole new whistleblower culture that has grown up, and in fact now the SEC, the Securities and Exchange Commission, and the Department of Justice get all sorts of complaints from all sorts of people. The Dodd-Frank law, which was passed about a year and a half ago, makes it very financially lucrative for people to quote-unquote blow the whistle on companies and to point out that this company or that company is violating the FCPA. Whistleblowers can make millions of dollars doing that, and so there's real incentive for them to call. Once the government learns about suspected wrongdoing, they can go out and interview people on their own. They can gather documents from third parties on their own without you knowing about it. But the first thing that the government is likely to hear is that the company is likely to hear from the government is going to be one of two things. It's either going to be a subpoena, which is bad, but is better than the alternative. The alternative is you're going to get a search warrant, and they'll come through your door and take what they want. A subpoena at least allows you to organize your response a little bit.
So if a company is approached by government agents either through the subpoena or through the surprise visit with a search warrant, possibly due to an FCPA violation, what should the company do next?
Well, the first thing you do is you consult legal counsel. You get a lawyer. One of the things you don't do is there's sometimes a panicked response that, oh my goodness, we've got to get rid of all these documents that might incriminate us. I hope they don't see this. I hope they don't see that. That is absolutely the wrong thing to do at that point, because in this day and age, there's almost no way to get rid of documents because almost everything's electronic. You're not going to get rid of things without a trace. You're going to be found out, and it's going to make everything much, much worse. So you get counsel, and then you start to deal with it on a day-by-day basis. Investigations are painful. They're expensive. Everybody wants them to be over with already. Yesterday, last month, please, we need to get back to our business. But they don't go away magically, and they don't go away overnight. You just plot ahead one day at a time, do the best you can each day, and you often get to the best result.
How long do these investigations sometimes take? Is there any kind of suggestion out there that they may take years, or is it months, or is there anything that you've seen in your practice?
A year or more is standard, and 2 years or more is not uncommon. Months, it would be a quick investigation.
And certainly for that period of time, there's a fair amount of disruption that the company's going to have to deal with in terms of responding to government inquiries, being responded to subpoenas and the like, right?
Members of the board of directors and management will be complaining that all they seem to do these days is deal with the investigation. They don't seem to be focusing on new products or new markets or areas for growth. They're just dealing with the investigation.
So what happens if you're found to have violated the FCPA? What kind of penalties can a company expect to receive?
Well, if it's a criminal case, you might be fined up to as much as $2 million per bribe, and if it's a civil case, it could be $16,000 bribe. It could be it'd be a lower amount. But what you have to understand is, if you're bribing a government official and you pay him the equivalent of $100 a week for a year, that could be easily viewed by the government as 52 bribes.
So the penalties can add up very quickly.
These cases can be extremely expensive.
How does the line get drawn between a civil and a criminal prosecution for a violation of the SCPA? Is there any guidance on that?
Intent is a big thing. What is their evidence of intent? What is the evidence of prior misconduct? What is the evidence of the extent? How extensive was this? Can they prove which individuals were involved, or that individuals actually knew what they were doing and intended to bribe people, or as opposed to, and when I say individuals here in the United States in management, as opposed to just somebody in the sales force in Kazakhstan or someplace.
And you had mentioned, I believe, in the article that the third parties, these distributors, these independent distributors in foreign countries, sometimes they're somewhat off the leash in terms of their behavior, and without you knowing about it, they can engage in activities that would violate the FCPA, but the liability will come back and hit you at home with your own company, right?
Anybody who is furthering the interest of the company can bind the company, as it were, for FCPA violations, perhaps not criminally, but civilly. And yes, even though they're off the leash, you have to get them back on the leash, and you have to make sure that they understand what the rules are and that they obey those rules. The government of the United States is making it increasingly plain that it will not tolerate companies that allow their agents to be off the leash, so to speak.
And is this a big issue with regard to employee education? I mean, I would assume that most companies have to really drive this point home about FCPA liability and what can and cannot be done.
Absolutely. It's essential, and the government has put out some guidance in the last few months that makes clear that it's essential that companies train their employees on the Foreign Corrupt Practices Act, and that this training go hand in hand with the Code of Conduct. I have clients who fly me around the world to train their employees in various parts of the globe in order to make sure that they understand exactly what they can and cannot do.
Thanks, Steve, for your views on this. Ensuring that your company complies with the FCPA requires a significant effort and rigorous ongoing education of employees, as Steve mentioned. It's best that you consult with an attorney who's well-versed and experienced not only with the FCPA, but also with approaches that the U.S. government uses in prosecuting criminal and civil cases against companies. We hope that you found this podcast helpful in understanding some issues regarding the FCPA. Stay tuned for our next installment in Computer Magazine. Until next time, this is Brian Gaff.
And Steve Huggard.
Feel free to contact us via email at bgaff@edwardswildman.com.
Or at shuggard@edwardswildman.com.
Thank you.